Sure, there's a trick to this.
Yes.
Oh. Yeah.
Good afternoon. Can you hear me? Can you hear me? Is this working? I guess it's already on. You don't need to press the button. So good afternoon, everyone. My name is Hiro Aragaki. I'm the director of the Center for Negotiation and Dispute Resolution at UC College of Law, San Francisco, formerly known as UC Hastings College of Law. And it's really my great pleasure to be able to welcome our distinguished panel and all of you to the special events today. This event is co-sponsored by UC Law SF, the United States Council on International Business, which is the U.S. National Committee for the ICC International Court of Arbitration, and the ABA's International Arbitration Committee. I'd also like to thank all of our supporting organizations, including Music Peeler, Jones Day, Arnold Porter, Wilson Sonsini, Norton Rose Fulbright, California Arbitration, and the Silicon Valley Arbitration and Mediation Center's Young Professionals Group. So this is one of several events that we are planning to roll out at law schools across the country to raise awareness about this exciting field of practice, but also to encourage students from underrepresented communities to get involved as a way of kind of diversifying the profession more. So in order to help us generate enthusiasm and also build some momentum for future events, we'd like to get your help to post impressions and feedback and any other comments you'd like on social media. So to that end, we have distributed slips of paper with the center's handle for various social media sites, including LinkedIn, Facebook, and I believe it is Instagram. So please do note down the center's handle and tag us. And that's very important so that we can have all of the posts in one repository so that we can share them with our friends and colleagues. Please also feel free to take photos of the panel or of the reception and post those as well. The one thing I ask you not to do is to record the entire panel. We will be recording this program separately, so you'll always have access to it on the internet in the days to come. So we have a large panel, and instead of having each person kind of do a presentation, we thought we would try to foster a conversational style. So I'm going to ask a question to maybe one or two panelists, and I'm really going to invite others who were not specifically asked to answer to join in the discussion, add your perspectives, and so on. The panel will go for a little bit less than an hour, and I'm going to reserve about 20 minutes or so for Q&A. So do hold your questions till the end. We really encourage questions. We'd like this to be interactive, so don't be shy. Those of you who are on Zoom, we welcome your questions as well. Just raise your Zoom hand and we will call you in order. And maybe I'll ask the panelists, no more than maybe 2 or 3 panelists answer any particular questions so that we can get to as many of the questions as possible, right? And then there'll be a networking reception that starts at 6:30, all right? So housekeeping matters out of the way, I think I can introduce our distinguished guests. So I'm going to start with Nancy Thevenin, who is online first. So Nancy Thevenin is an international arbitrator and mediator based in New York City and a member of the ICSID panel of arbitrators for the Republic of Haiti. She also serves as general counsel for the USCIB. In that capacity, she manages the USCIB Arbitration and ADR Committee, which, among other things, provides assistance in the nomination of U.S. arbitrators and makes referrals to parties seeking arbitration practitioners and arbitrators. With Jonathan Greenblatt, who's also on our panel, she's co-chair of the USCIB/ICC Task Force on Diversity, Equity, and Inclusion, which aims to address the need to diversify the profession at the senior levels and ensure that the future of arbitration in the United States is more diverse through the cultivation of younger practitioners. So to my immediate left is Andrea Gross. Andrea is Principal Counsel and Manager of Litigation Americas for Bechtel Global Corporation, where she's responsible for U.S. and international litigation, arbitration, and regulatory matters across the Americas region. Prior to her work at Bechtel, she was an assistant general counsel at a biotechnology company, an assistant U.S. attorney in the Eastern District of California, and a litigation associate at a major law firm. So to her left is Imani Tisdale. Imani is a graduate of Brown University and Harvard Law School. Following her clerkship with the United States District Court in Connecticut, she joined Arnold and Porter in New York. Her practice focuses on the representation of sovereign nations, state-owned entities, and private sector entities in high-stakes international arbitrations and domestic disputes. Imani has extensive experience working with clients throughout Latin America and has used her advanced Portuguese language skills to advocate on behalf of Brazilian clients. So to her left is Steve Smith, who really pioneered the practice of international arbitration in California with a focus on complex, high-stakes disputes. He's worked in the energy, infrastructure, mining, chemical, and life sciences fields, and has significant experience resolving cross-border licensing, distribution, and joint venture disputes. He's been the lead advocate for clients in numerous ad hoc and institutional arbitrations, including under the UNCITRAL, ICC, LCIA, SIAC, and many other institutional rules, and has handled matters involving sovereign entities from 5 different continents, including before the Iran-US Claims Tribunal. He regularly serves as an arbitrator and taught the international arbitration class for many years at Stanford Law School. To Steve's left is Jonathan Greenblatt, who is a retired international arbitration partner and former deputy practice group leader at Sherman and Sterling. He currently practices international arbitration through J. Greenblatt International Disputes PLLC and is co-chair of the USCIB ICC Task Force on Diversity, Equity, and Inclusion. He is also chairman and co-founder of Legal Innovators, which identifies, recruits, and mentors junior lawyers who were missed in the traditional big firm OCI hiring process and places them with law firms and corporate legal departments on a 1 or 2 year trial basis with the objective of receiving full-time employment from those firms and corporate legal departments. Wow, students, go talk to Jonathan after the panel. To Jonathan's left is Giorgio Sassin. Giorgio is an associate with Music, Peeler, and Garrett in Los Angeles and is a member of the firm's international arbitration and litigation and construction practice groups. He has extensive experience on domestic and international high-value complex commercial, construction, and energy disputes, and has represented clients in the United States, Europe, the Middle East, and North Africa. He earned his LLM in international commercial arbitration from Stockholm University in Sweden, and also attended the Sorbonne in Paris. And last but not least, Savannah Billingham Heminger is a third-year associate at Troutman Pepper in DC, specializing in both domestic and international reinsurance arbitrations, while also growing and supporting the firm's international commercial arbitration practice. She's a graduate of Pepperdine Law School, where she received certificates in international and comparative law and a certificate in dispute resolution. She started down the path of international arbitration during law school when she interned in Wilmer Hale's International Arbitration Group while studying abroad in London, wow, and later at CPR, an arbitration institution in New York City. So that is a tremendous and stellar accomplished panel. We're so fortunate to be able to have you all here today. So let me kick off the discussion, and I wonder if I could ask Giorgio first. So I think of maybe Giorgio and Savannah and Imani as more of the mid-level or junior level associates who are doing a lot of this work day in and day out. And so what is your day-to-day work like in an international commercial arbitration practice, or in even investor state arbitration practice? And how is it different from doing domestic litigation? Giorgio, could you kick us off?
Yeah, definitely. Do I push this button?
I think you just bring the mic to your very close.
Yeah, so
to you.
I think the main difference between an international arbitration practice and a domestic practice is the type of disputes that you're going to see on a day-to-day basis, and the value and complexity of the disputes, and the legal issues that are involved in those disputes. I mean, they run the gamut from public international issues to private international issues to treaty and really complex commercial contracts that go across borders, multiple different borders. And so that's something you don't normally see in a domestic normal litigation.
Great, thank you. Savannah, would you like to add anything to that?
Yes, sure. So, I mean, I think just piggybacking off of the idea of the complexities, when it comes to an international arena, there are so many other factors to consider between the parties, particularly cultural identity and how that plays a role in the dispute resolution process. And in domestic arbitrations, generally you have parties that will be on the same playing field in terms of those understandings.
Great. Others want to chime in on this point?
Well, just adding to the day-to-day, I would say that international arbitration is often more predictable. Often when you're in domestic litigation, you might find out in the beginning of the day, you have to write something right away. Whereas in international arbitration, at least in my experience, there's a lot of scheduling in advance. So you have an idea of what you need to be doing. You're going to have something to do every day, but at least you know when it's due.
Steve.
I'll add just one other point. So in international arbitration, as opposed to domestic litigation, you're not operating under one system necessarily. So in domestic litigation in federal court, you have the Federal Rules of Civil Procedure, Federal Rules of Evidence. There's you get to know the different judges. There's a very distinct process. And in international arbitration, there's also a process, but you could be operating under completely different laws. So, for example, I have an arbitration right now. It's venued in Hong Kong. It's between subsidiaries, affiliates of a French pharmaceutical company and a Taiwanese company and a Chinese company. It's controlled by Hong Kong law. And aspects of Hong Kong law that aren't substantive can also seep into the dispute as procedural issues arise. And so you have to be able to get your arms around Hong Kong law. Hong Kong law is a derivative of English law, and I have an English law degree, so that helps. But you want to staff the matter with people that are conversant in that law. And also it's very helpful, this is a life sciences dispute, to have people that are adept or knowledgeable about life sciences matters.
So I'm hearing very complex disputes in general, a lot of international flavor, the importance of being culturally sensitive to different perspectives. Steve, you mentioned procedures. So one procedure common in domestic litigation is discovery, which is often the bane of junior associates' existence. Can we talk a little bit about discovery and how prevalent it is in international commercial arbitration compared to domestic litigation? Giorgio, did you have your hand up?
Yes, that raises a really good point. I mean, the difference between litigation and international arbitration, I think, is most prevalent in the discovery or fact-finding process. In U.S. litigation, discovery is very costly, time-consuming, interrogatories, depositions, document productions that are very, very wide in scope. Whereas international arbitration, usually what happens is each side submits their documents that they think are important to back up their case. Then there's usually one round of document production requests. There's witness statements, and then instead of having depositions, you'll cross-examine the witness at the hearing. So I think those are probably the main differences, I think, between international arbitration and domestic litigation.
If I could just weigh in. So in the U.S., in discovery, of course, you're governed, if you're in a federal case, by the federal rules of civil procedure. When you get into an international arbitration, if anything, and I'd be interested in the perspective of the other panels, there's an anti-American bias on the part of most practitioners and arbitrators. And it really starts with two things. They don't like the jury system, and you won't get a jury, of course, in an arbitration, and they don't like U.S. discovery. And they think that, U.S. lawyers are going to be over aggressive on discovery and tend to tilt towards what they know, which is the federal rules of civil procedure, document requests that say all documents relating to some broad subject. And that's not going to be permitted in most international arbitrations, which are governed by a different set of rules, usually the International Bar Association rules, the IBA rules, and they're much more limited. It's not like you can't get any discovery, And if you push too hard as an American litigator, you're going to play right into some of the prejudices of the tribunal that you are in front of, I think. So that's what makes, I think, the multiculturalism that has been alluded to really fun, because you have to be sensitive to those different perspectives.
Yeah, just to underscore that point. So in US discovery, you get document requests, any and all documents relating to the general subject. And under the IBA rules on the taking of evidence in international arbitration, which are really becoming the convention for document requests in international arbitration, people get offended if you refer to it as discovery,
Right.
because you're importing an American concept into this international procedure. And some people get really upset about that. So in any event, so under the IBA rules, for the document request to be permissible, it has to ask for documents that are relevant to the dispute and material to its outcome. So you can see that's a much narrower set. And usually you're asking for a particular document or a particular set of documents, never a broad category. If you start out any and all documents relating to something, you're likely to get that, you'll draw an objection and you're likely to get that request denied.
We have objections just like that going in tomorrow before.
So overall, good news, it sounds like, for junior associates who would otherwise be stuck in American style discovery. So good point to keep in mind. Imani?
I do want to add, though, for every rule, there is an exception, and there are people are leaning now towards nitpicking, I will say, in when it comes to this process. So even though, as my co-panelist said, there's a push against the American system, the issue I find is when it's an American company. Actually, I'll take it back. When it's an American law firm representing a foreign entity, and it's an American law firm representing another company, sometimes those systems still bleed their way in. And then there becomes this issue of fighting back and forth of, does this document exist? Have you given us everything you need? It's not the same system as federal rules of civil procedure, but some of these things come out.
You want to say something?
No, no.
You're okay. Okay. I just want to make sure you didn't feel excluded from the, okay. Okay. So let me follow up though, because I think.
Hero, I have a comment.
Oh, yes, Nancy. Yes, please. Welcome.
Thank you. I thought it was very interesting what Imani said. And to follow up on that, I found that she's right with the U.S. law firms or the U.S. parties. Sometimes it's mostly the law firms. And that's why one of the wonderful things for me about international arbitration is that even while you're drafting your arbitration agreement, you get to design or think about the design of the process to help resolve any disputes that may arise. And then when you do have the arbitration, when the dispute arises, you start thinking, am I the one who's going to need a lot of discovery, for example, which Steve is right. In international, we call it disclosure. We don't call it discovery because of the, the fear of US style searches going on. But so when you think that you're the one, you want a nice streamlined process that follows the international model, which is embodied in the IBA rules of evidence, you're going to select arbitrators from for example, civil law system, or so that these arbitrators will be less inclined to allow for broad types of discovery. So there's a lot of strategic analysis that happens in the design of the process when it starts. And that's one of the things, because you get to select your decision makers, your arbitrators, you also take that into consideration, just how much disclosure or discovery you want.
Great. Thanks for that, Nancy. And do chime in whenever you'd like to participate. I can't see you from where I'm sitting, so don't hesitate to come in. Jonathan?
Sorry, just one more point, because each thing leads to another point. There's a consequence to the more limited discovery, which is your cross-examinations at the hearing are very different from what they would be in a U.S. hearing, because you don't have all the documents and emails and other things that you have the benefit of. So it's a very different kind of procedure. You're asking questions you might not know the answer to, which you wouldn't do in a US court proceeding, but it's sort of understood you might do that in an arbitration. So it all plays out.
So one of the important things I think that Nancy, you brought to the table is this idea of process control, or being able to design a process in arbitration in a way that you might not in litigation. And the other thing that you mentioned was choosing civil versus common law, and this kind of difference, cultural difference. I think maybe Steve or Jonathan, you referred to the American lawyer or the anti-American sentiment. And there is this image of the kind of aggressive, adversarial US based lawyer. Would you say that international arbitration practice is a little bit more genteel? Is there a sense that, you know, Europeans who tend to dominate in this area are a little bit less aggressive and more cordial in the process? Is it somehow less adversarial, would you say, than a traditional domestic litigation?
Yes, I mean, it's the practitioners in this practice are members of a club. And, you know, you have to get along because your adversary, your counsel on the other side may be an arbitrator, you know, in your next case. And so I tend to believe that it's more convivial. You know, people do get along. Advocacy is less strident. It may be a little bit more intellectual, say, but you know, harsh cross-examinations are not are frowned upon for the most part. And I would say that the Americans that practice in this area with a dedicated practice, they have adopted the conventions of the practice globally. And so, you know, we don't go for extensive discovery because we know even the American arbitrators that are very well regarded know what the system is and are not going to, you know, reward requests for very, very broad discovery. You just know that. Where you see the difference, though, is where you have, and I've been the sole arbitrator in cases where you have two American firms that don't really specialize in international arbitration. And then what they try to do is domesticate the process. And as an arbitrator, you try to resist that and guide them to a more efficient proceeding. But that's where I see, you know, the sharp elbows of the American litigator really on display.
Yeah, there are different flavors of international arbitration depending largely on the nationality of the counsel to some degree. I want to bring you in to the conversation, Andrea. So I'm going to ask you something about skills, marketable skills. Young lawyers and students who are interested in getting into this area, what are some of the most important and marketable skills for international arbitration?
Yeah, so actually, I think there's a couple of things I would mention, and they've all been sort of alluded to already by the panel. So obviously, you need a baseline in understanding how to be an internet, you know, understanding international arbitration. But in addition to that, I really think there's you bring enormous value from the other parts of your background. So, for example, Imani mentioned speaking Portuguese. So I think understanding industry, having a background in biotech, Steve was talking about, you know, one of his matters being biotech. No one is thinking that when you go into the field of international arbitration, you're leaving that background behind. Far from it. You're really, really bringing it with you. It's a huge asset to yourself and to the team that you're working with. So don't leave that behind. Second thing alluded to by Steve, I think, is if you're meeting with a outside counsel to discuss a new matter, it's really valuable if you have sat down ahead of time and thought about what rules are going to apply, what's the seat of the arbitration, all the early procedural issues that might come up. I, as an in-house counsel, I'm really busy. I have a lot of matters. And I haven't thought about those things. Another thing that I think really you can bring as an international arbitration student is taking the time ahead of time, look at the rules, look at the seat, think about the early procedural issues. The last one I'm going to mention is going to be a little controversial after this discussion that we've just had. I think to some degree, a training in US litigation is actually really valuable in international arbitration, really valuable. And if you have the opportunity to go to a firm where you can do both, I suggest you do it. The thing, I'm trying to put my finger on it because I agree with everything the panelists have said about sharp elbows and some anti-American bias. I think that's all true. But I also think that US litigation really focuses on emphasizing the themes of your case, telling the arbitrators what your case is about, why they should care about your case, why they should care about your client. All of that is really, really important in presenting a case. And I think you really get that through US litigation skills more than international arbitration. But it might be controversial. Others might not agree, but I think look for exposure to both. Just don't forget that you can't throw as many elbows in international arbitration, right? You got to transition.
Yes. So I agree with everything you said. And in international arbitration, the case goes in writing before the hearing. So usually you have 4 rounds of written submissions. And so the claimant will submit, a statement of case or a statement of claim, and that'll include a very lengthy memorial, what we refer to as a legal brief in, domestic parlance. But they can be very extensive, 200, 300 pages long. And then they are supported by written direct testimony of your factual witnesses, and then the written reports of your experts, and then all of the documents that support your case. So as a young associate, I was always told, master the documents, and then you just become invaluable. So I'll give you that advice. But there's really 2 skills that are very important because of the submission of the case in writing. One is very strong analytical skills, legal skills, working with witnesses, developing the facts, owning the documents, so that you're at every witness interview. And then also legal research and writing, preparing parts of these very extensive, written submissions. And that may sound daunting, but one thing I've noticed over my 40-year career is that everybody improves dramatically in those areas. I mean, you start out and you're writing maybe small portions, 5 pages, 10 pages of much longer brief, but by the end, you're sort of the person that is, taking the bull by the horns and doing the first draft. And you're, I can't tell you, if you stick with the practice, how much better you'll get over time, even though it is a little intimidating. And then the other thing I would say is hone your oral advocacy skills. And in international arbitration, you really do that at procedural conferences and also at the hearing. But the best way to do that is to find a mentor in the field who's looking after you and make sure that you're getting stand-up opportunities. And I've done that with people going, working with me on the way up, and I've seen them just blossom as oral advocates, and it's really gratifying. And this is a segue to what your point about litigation. And if you get an opportunity to work on, domestic litigation, preferably international litigation, but you can take depositions and you get opportunities for, arguing motions in court and stuff like that, do that. And if you don't have that opportunity, look on the pro bono side. And just be hungry for opportunities to get that stand-up role, because it'll cross-fertilize your skills in both areas.
Yeah, I totally agree. And I don't think it's controversial what Andrea said at all. I mean, I was a litigator for 20 years before I really segued over to being an international arbitration person. And my answer to the question of what skill do you need to develop is advocacy skills, whether it's oral or writing. We are in a different forum, but we are in an adversarial system. This is not a mediation. I mean, don't confuse it with a mediation where someone's trying to help you settle the case. You're advocating for your client, and the conviviality only goes so far. I mean, it may be that you're more polite and you grant some more courtesies along the way, but when you get in it'll be like a room like this, and there'll be 3 arbitrators sitting up here. It's like being before any tribunal or court, and you're sitting over there, and your other side is sitting over there, and it's like being in a courtroom. So your courtroom skills, and I totally agree with Steve on taking depositions if you get a chance, because these cross-examinations, and I was struck by this in a case that actually I worked on where Andrea's client was involved in Oman. Because there was no discovery, almost all the cross-examination was, to my way of thinking, a hybrid between cross-examination and deposition taking, because you're actually trying to discover some things during the course of the cross-examination, which you generally don't have to do in a civil case in the US because you've got so much material already. And it changes, as I said before, the way you cross-examine, but you are still cross-examining. I mean, you may not want to pound the table. And I was in a case where a guy from a very prominent US litigation firm, trial lawyers, said that they, he was extremely bombastic in the case. To me, it didn't resonate in some negative way because I'm totally used to it. But all the other lawyers on the case, most of whom were from France, said that they in the tribunal felt it was like fingernails on a chalkboard listening to him. And, it just didn't, to me, it was just kind of aggressive, but not too bad. They thought he was really bad. So you just have to be aware of that.
Interesting cultural issues, cross-cultural issues. So I'm going to shift gears a little bit and talk about career paths in international arbitration. So we're very fortunate that we have folks who work at law firms. We have Andrea, who is in-house, and we have Nancy, who works at an institution, among other things, being an arbitrator as well. So Nancy, if I could turn to you first, tell us about your career path and about the different ways that one can be involved in this field of international arbitration.
Thank you, Hiro. I was listening to the comments, Steve, Jonathan, and Andrea, and thought, wow, that was my path. Several years ago, over 20 years ago, I started practicing. When I graduated from law school, I knew I wanted to do international litigation, but a lot of the firms at the time, I started in Florida, they didn't even define their practices as international litigation or anything. So I was a litigator. I worked at a small firm. I had at the peak about 30 cases running. I was in court every week, taking deposition, meeting clients. I had trials, bench trials, no jury trials, but those skills I found were exactly what I needed when I got my first arbitration, which is complex. It is quite adversarial. I call it steel covered in a velvet glove. The language is different. It is much more diplomatic, but that was definitely what was needed. So I started as a litigator, and then I moved to become the Deputy Director of Arbitration and ADR for the ICC for North America. What helped there was my practice as a litigator, as well as the work I was doing in the Florida State Bar International section. We had this theory of a rising tide raises all, ships, and we were trying to develop the international arbitration practice in Florida. So the people I met, I organized conferences, meetings, and that helped me a lot when I went to work for the ICC in educating corporate counsel and other users of ICC dispute resolution. And from there, I was responsible for North America. I moved to Baker McKenzie, a large firm where I was responsible for managing their international arbitration practice group. That was really big because they're all over the world. And my project management skills that I had gotten from ICC really helped there. And of course, the contacts of people I knew. I did that for about 4 years. And then I decided to start my own practice. And while I started my own practice, I started teaching at St. John's because I love international arbitration. I love what I have seen this industry develop into in the past 20 years. I know that each of the practitioners have had something to do with that change, which I think is positive. We immediately recognize the problems and we are thinking on ways to solve them, which is not something you can say about a lot of other fields. So teaching was, I just love it. I love being able to share what I know, what my experiences with the students. And then I was recruited by ICC USA, which is the US National Committee to the ICC, where I used to work before, to help rebuild their office, which is what I've been doing. And in that role, I appreciated very much, not only for doing the things that needs to be done to manage the group, but it provides me with an opportunity with people like Jonathan and others to really start looking at a problem, the lack of diversity in the profession, and address it in a meaningful way, supported by data. So that's what I'm saying.
Thanks, Nancy. And I wondered if you could just say something briefly about career opportunities at institutions like ICDR, ICC, SEAC, and so on, because I think that's something that many students don't really know about, that they could get into international arbitration or get a foothold, in the field by working at an institution. Can you say a little bit more about those possible opportunities?
Absolutely. And thank you for following up on that question. So as students right now, I would recommend that you all join the Young Arbitrators groups. International arbitration, we have a lot of institutions that arbitrations are run or managed in accordance with those institutions' rules. So each of these institutions have a young group. The concept is it's free to join, the meetings are free, but you're learning something, and afterwards you're networking. Very similar to what's happening tonight for you all in San Francisco. So you're networking, you're building your network of people, believe it or not, that you will see in this profession in the next 10, 15 years, who will be your arbitrators, co-counsel, et cetera. So ICC has the YAF, Young Arbitrators and ADR Forum. It is about 24,000 practitioners from all over the globe, Africa, Asia, Latin America, Europe, and the Americas. There are opportunities there. I say when you join YAF, raise your hand to organize a panel, something similar to this, or and provide yourself speaking opportunities. You're learning, but it also provides young practitioners with an opportunity to see and be seen. ICDR has one, CTAC has one, SEAC has one. No matter what region you're interested in the world or where you're from, they all have one. So I would highly recommend that you you join them because it's free to join. The other thing is a lot of the institutions have internships. Now, we didn't mention the fact that international arbitration, unlike litigation, is private. You don't know it's happening except for the people, for the most part, for the people that are involved in it. So you ask yourself, how do you get experience on something that you're not even allowed to come into the room? It's not like court where you can just go into court and see a trial. So many times, the only way for you to really get a sense about how these arbitrations are working, ideas about these, the different cases, is to intern with an institution. A lot of the institutions offer 3-month internships, if not more. And it is an opportunity with the possibility of stipends. And it is an opportunity to be there behind the scenes, to see all of these cases, to meet counsel, see the arbitrators to really have a perspective that is very, very difficult to come by in our field unless you end up at the big law firms and are working international arbitration cases constantly. So I'll stop there with the recommendations. I'm sure there are.
Thank you, Nancy. That was super helpful. Let me pivot now to Andrea, because Andrea, you have worn several hats now. You were in a law firm, now you're in-house. How would you kind of compare and contrast your in-house role versus being in a law firm in this field?
Yeah, so that is, I have had a lot of hats. I was, I think you mentioned in the introduction, I worked at a law firm at the beginning of my career. Then I was an assistant United States attorney. Really learned, I did affirmative civil enforcement in that role. So I really learned to be more of a plaintiff, which is very different than some of more of the kind of the work you do at a big firm. And then I went in-house. I think your role in-house is really very different in that, well, first of all, you never know what is going to come across your desk. We were talking about this before the night started. You know, it can be very small things. It can be very big things. And you're going to be responsible for sort of thinking about how to deal with all of them. And I think from my perspective, what's been helpful to me is the varied background that I have really helps me just kind of immediately react, because I feel like I've seen a lot in my career because I've done a lot of different things. So as things come in, I kind of have a sense of, you know, what might be the right way to handle them. I do think in-house, your role is more of a project manager. I think Nancy mentioned project management at a law firm. You know, when she was managing a group of lawyers at Baker McKenzie, but also as an in-house lawyer, you're managing the work of your outside firm, and you're helping your client, your internal client, understand everything that's going on and make all of the strategic decisions that they need to make in connection with the arbitration proceeding. So you're managing both those pieces. And I actually think that international arbitration is really challenging to manage, just for me personally, because of the lack of predictability that I think Imani and Steve both mentioned. You know, there's not as many rules, there's not as much of a set schedule. And a big part of your job, and this is where I do really like it when outside counsel come in up front and really help me understand it. A lot of your job is educating your internal client, because every case is going to be different about what to expect, so that all of those strategic decisions that they're going to have to make, all the planning that they're going to have to do, they know how to do it.
Great, thank you. So our time is actually quickly running by, and I do want to get to an issue that I think is near and dear to many of our hearts, which is this question of diversity, equity, and inclusion in the profession. The world of international arbitration has long been seen as very much an old boy network, and the question I'd like to pose to really anyone who'd like to volunteer is, how far have we come in recent years, and what work remains to be done? Jonathan.
We haven't come too far yet. We are making strides. I mean, in the arc of my career, it really went from an old white male bastion, particularly in Europe. But that has been changing, and I have to say the ICC has been in the forefront, particularly on gender diversification. There's far more international arbitrators who are women. There's more practitioners. There's people leading practice groups in big firms now. So I think there's been strides, and some of the institutions have been driving it. I think clients really do have to drive it as well, and they need to say to their law firms that they want diversity. They want diversity on their teams, and they want diversity in the tribunals that they pick, because law firms respond to what clients tell them. That's one thing. On the racial and ethnic diversity, it's a geographically diverse practice by definition. So you're going to be dealing with people from lots of different cultures, but looking at it from a US lens, and a lot of us teach in law schools. I've been teaching for almost 20 years, probably maybe 18 years or something like that at GW Law School. And we've had very little domestic racial diversity in the class. We've had international racial diversity with LLM students who often go back to the country they're from. But and that's something that we all want to change. So there are two initiatives, and Nancy talked about it, and I'm sure she'll jump in, but there's an ABA initiative to do this, and which a number of us are involved in, and there's the USCIB initiative, which is the ICC and the US initiative, and we're trying to tackle it from two angles. One is to get more senior people, diverse practitioners, to sit as arbitrators and do arbitrations. And really, I think to Andrea's point, a litigator who's been practicing their whole career can easily transition to be an arbitrator. You don't have to have grown up and the ICC and other things will do basic transitional courses to help people master the procedural things that they don't know. But there's a lot of skilled people in-house and in law firms who can transition over, and we're trying to attract them. And the other thing we're trying to do is what we're doing here, which is get younger practitioners interested in this field so that we begin to have people populating practice groups like the one I was in, to begin to rise up the ranks and ultimately become partners and leaders in the practice area.
And just to dovetail on that last point, one of the biggest things that we're doing right now in California is trying to engage law schools. And so we have a new fertile ground of new practitioners who are loving and passionate about this field and can make it flourish in California. And so seeing all your different faces out there and different walks of life, I think it's really amazing. And I really hope that all of you continue pursuing this passion of international arbitration.
I will just add that so the legal career is not very diverse in and of itself, especially if you look at law firms. And international arbitration through the law firm lens is a smaller subset of that. So it's going to be even less diverse. What needs to happen is more people opting in to trying to get into this career. Because what I found with this field is many people are pushed out. The lack of encouragement I have had to become an international arbitration lawyer is astounding. But at the end of the day, I'm an international arbitration lawyer. So I think it's very important for everyone in this room, everyone watching online, and, tell your friends, it doesn't matter what it looks like right now. You can be a person that changes what it looks like.
So assuming that you've piqued the interest of people in the audience, sort of what advice would you give them in terms of better preparing themselves to be competitive for jobs like this? Courses they should consider taking? Should they be on journals? Will that help with the writing issue that was mentioned earlier? Moot courts, perhaps, the VIS International Arbitration Moot Court. How much do all of these things help, and what should people be thinking about in terms of planning ahead? Savannah?
So really any and everything that you mentioned there, I tried to do all of those things. Whenever you have an opportunity, just try it. There's no harm. You'll learn whether you like it or not through that process, whether that's journals. If you can't get on a journal, then even just submitting pieces of writing to other journals. They're constantly accepting any articles that even students will draft. Going to networking events when that's possible. Getting involved, I think like Nancy said, in the young arbitration groups, whether that is, institutions or a lot of local areas will have arbitration groups. So there's a Young Arbitrators DC group. I think it's also in New York. I imagine there's probably also a San Francisco one. And just meeting people, talking to them. People love to talk about what they do. So just ask them questions and they'll be very willing, for the most part, to help you out and help you figure out what you would like to do. Beyond that, I was unfortunately not able to do the VIS moot, but if that is an opportunity, that is a great experience from what I hear as well.
Is Jessup still around? the Jessup move for?
Yes,
so, yeah.
it is.
So that's another one.
Mhm.
Does Hastings doesn't have the CVS, does it?
We don't at the moment. I'm hoping that that will change.
I mean, this has to happen here. This is one of the greatest things I ever did in law school. It takes place every year in Vienna and Hong Kong. You start out writing claimant's brief, then you write respondent's brief, and then you prepare for oral arguments. And then you go to Vienna or Hong Kong. And in Vienna, for example, there's 300 schools all over the world, over 3,000 students. You're there for like 2 weeks almost competing. And it's the greatest experience I ever had. And for example, one of our teammates at the University of San Diego, he made it won best oralist, and he was given a job at Wilmer Hale afterwards. I mean, so there's possibilities, and that you get yourself out there. I really think, and UC Hastings or UC Law SF, I apologize.
It takes some time to get used to.
Sorry. I really got to get into this Women's Viz.
Yeah, and there's also an organization called California Arbitration, CalArb, and for students, admission is free, and we're sponsoring a writing competition in the context of international arbitration. And it's I think the topic is innovation in international arbitration, and it's purposefully broad. So it could be procedural innovation. It could be, technological innovation, but in any event, I think the competition starts soon and will end at the end of April, and there's going to be a $2,500 prize. It's the first one. So one, join CalArb. There's a lot of international arbitration programs that it's promoting and advancing. And then also we're reaching out to students, and with this writing competition, it's something that you can put on your resume. And if you win it, you get, the advantage of the prize.
Just one thing that it might be assumed, but I don't want to assume it. Take as many international arbitration courses as you can, because when we're looking at CVs at the end of the day, we're looking at a lot of things, but interest and familiarity with the area is one of them when you're at a junior level. So you can tell when you're reviewing someone's CV whether this is something they seem to have touched and liked. And, there's certain courses that you will have taken: commercial arbitration, investor state arbitration, international business law, et cetera. If you sprinkle that into your transcript and you've done well in those courses, some of the people teaching those courses are very plugged in to the network. And if you do well, you can get a recommendation. So those are definitely do that.
Yeah. And I would also take a public international law course. It's just foundational. But also international commercial arbitration, investor state, international business transactions. Those are all things that would be very helpful.
Yeah, Steve, can you just describe the difference between international commercial arbitration and investor state arbitration so everyone is clear? Because that's really unique that many students may not have encountered.
So investor state arbitration is a case where an investor has a dispute with the country in which it's invested, and there is a treaty that governs the investment. And there's an institution in Washington called International Center for the Settlement of Investment Disputes, ICSID, along with other institutions such as the ICC that administer these cases. And so they tend to be controlled. They are controlled by public international law. And they're a subset of the international arbitration practice. International commercial arbitration is when you have a contract between cross-border counterparties, and they have agreed in their agreement to include an arbitration clause, which is a separate agreement to arbitrate, that specifies the main features of the arbitration. And that's a commercial dispute. It could be a dispute between, Bechtel and, the owner of a power plant that it built, which is the case that we did together in Brazil. It could be a dispute between life sciences entities. It could be a dispute between a contractor who builds a mine in Peru at 16,000 feet for a Chinese owner. And then there's a dispute over, the engineering of the mine. So they're at bottom, they're contractual disputes and they're commercial.
Right. Excellent.
Oh, yeah. I just wanted to add, in terms of things that you can do, really do anything you are interested in, do it extremely well, and make sure you tell people why that transfers into international arbitration. I say that because for me, I really care about learning Portuguese. And so during my law school career, I spent a semester in Portugal and I spent a semester in Brazil. And because that advanced my Portuguese language skills, it made it possible for me to work on Latin American cases, specifically those in Brazil, during the arbitrations that are happening there. And so I say all of that because every single thing everyone has said on this panel is reading, writing, researching. So any career in the law is going to give you those skills. So just do them very well. And the sooner you realize you want to do international arbitration, the better. Because if you decide to go to a law firm, I would highly recommend telling that law firm that it's your first choice, trying to get as much work in it as possible, because the sooner people realize you are interested in it, the more they'll take you seriously on actually putting you on those cases.
Savannah.
Yeah, I just wanted to add one more thing that was suggested to me during my last semester in law school that I found very helpful. And it's also a very approachable thing to do, I think, was some of the more international groups or institutions that relate to arbitration or transnational business will have mentorship groups. If you can sign up for those or apply to them, it's a really great opportunity to get to know other people in the field, potentially other students or young practitioners. So you get to learn more about what's going on in the field and kind of get your feet wet without any, intense commitment like an internship or something along those lines. So you get to learn a little bit more. You get to hear from people who are actually practicing, and it advances, your ability to meet others and, potentially secure a job.
Hi, Hero.
Yes, Nancy.
So these are great. I'm in front of my computer. So I have posted on the chat a link to the ICC YAF, ICDR, Young and International CPRs, Y and ADR, a link to Cal Arb that Steve Smith mentioned. And Savannah just mentioned mentoring, and Arbitral Women has an excellent mentoring program. One of the really that I find works or has worked well. So I posted links there. And I had a comment about the difference between investor state and international commercial arbitration. And what I tell people is, when there's a dispute, or if you're sitting with your client and you're thinking about where they're about to invest, you think about if there's a dispute, how is it going to be resolved? So you're looking at negotiation, mediation, or other types of amicable dispute resolution. Litigation, if it's international, you're going to pick arbitration, but then there's, which will be your commercial arbitration, cross-border that Steve talked about. Then the other aspect that you should always be aware of as a transactional lawyer or as a litigator is the investor state option. How are you going to design the investment to take advantage? Because that is another tool in your toolbox as a litigator of this treaty. So you can have commercial disputes. You have a contract, but the overlaying that contract is a treaty regulating the relationship between the investor and the country. And so you have public international law issues with respect to certain defenses or the interpretation of treaties, while you also have a business dispute, a commercial dispute. So it's quite special. But if you have the opportunity, I confirm everything my co-panelist said, to take as many of these classes on dispute resolution as you can.
Right. That's great. Thank you, Nancy. I'm going to give Giorgio the final word because we have actually flown through our time and I really want to make sure that we have enough time for question and answer. So Giorgio.
Well, I'll try to do my best to conclude it in an appropriate way. That I think that, one thing you should think about if you're really passionate about this field is taking the road less traveled, because sometimes this field is difficult to get into. But if you work hard and you're passionate about it, you don't give up, you can get into it. For example, I couldn't get into the field after my JD, so I took an LLM at Stockholm University. I then worked in Paris for a while, and then I decided, well, I wasn't getting the big firm associate position, but I was getting opportunities at smaller firms in the Middle East. So I went and worked in Beirut for a while, working for a very prominent international arbitration practice, where I was getting an amazing hands-on experience, where I was getting to write briefs and go to oral arguments, go to the arbitration hearing in Paris, and sitting second chair in a $140 million construction dispute, as a second, third year associate. I mean, this is an incredible experience. And so I think that if you are passionate about this, be open-minded to whatever path takes you to get to this field, and to be where you want to be. And that's really my favorite case in international arbitration, was taking this long path and then being in Paris in the hearing room at the ICC and just being like, wow, I can't believe I made it. I didn't give up, so really don't give up if you're really passionate about it.
Excellent advice. Thank you, Giorgio. So let me open it up to questions from the audience. Those of you on Zoom too, please do just raise your Zoom hand. Any questions? Don't all ask at once. Yes, in the back.
Thank you very much for talking to us. I think I had a question more on the substantive matters, but you mentioned the difference between US procedures and arbitration procedure linked to discovery. And I just wanted to know, what did you think it means in terms of administration of justice? I'm guessing that the discovery process has a meaning in the US. There is a reason why you do it like this. So I just wanted to know what it means for arbitration.
I have to say, having grown up in the US, I feel some things get left unknown in a case through the more limited discovery that if we knew, if the other side knew, would change the perspective on the case. But since you don't have to produce those internal documents where people are writing bad things, which are the bane of litigators' existence. And I do a presentation to clients, I think, Andrew, you may have seen it, called The Creation of Incredibly Stupid Documents, which is about emails mostly. And you don't get those, but some of that stuff is inflammatory, Now, whether it goes to the heart of the case is another matter. But I do think there are times when the more limited approach leaves some things unknown that could be material.
Yeah, and one way to do that is at the hearing, cross-examination is limited to the witnesses that have been put forward by the other side. And so you can, through the choice of who your witnesses are, really eliminate whole parts of the factual narrative, and sort of engineer the system, play the system, game the system. And in the US, you wouldn't be able to do that. I mean, there would be, a notice of deposition, the person would be deposed and then would be called to trial. And that just isn't the norm in international arbitration.
Yeah, I think the maybe one of the potential answers to your question is that there's a difference between the civil law system and the common law system. And I think there's a theoretical, philosophical question that you're answering when you're trying to get to the truth. I think the common law US system is more, we have to find the truth, whereas the European system is, well, what is the truth? And so they don't really have this, we need to find everything, we need to discover, so we need to know all the facts, because the Europeans consider it, well, we're never going to know the truth. So I think maybe that has something to do with why there's a different system.
Other questions?
If I can add, Hero,
Yes, Nancy.
I that's a great question, and I'm gonna gross generalization, but I've seen that the civil law system, they bring a case when they're prepared. They have done a lot of the research, they've gotten the documents, and they are prepared. Whereas to defend the case. Whereas the Americans are, we have the colorable, we have a case here, we know we have a case here, we sense it, and we're gonna get all the evidence we need from the other side. We have some and we're going to get it. So it is a different approach.
Yeah.
And I think what Georgia said was the closest I've come in terms of, going after the truth. What is the truth? To try to understand these different approaches. And when you think about the US system, that the civil procedure rules did not always exist, right? They were established, I think, in the early 1900s. So how did we live as a society in getting at the truth before depositions, interrogatories, requests for admissions, et cetera? So anyway.
Yeah, this is one of the interesting things about this practice area is just the cross-cultural, elements and the different ways of approaching similar problems. We had another question. So Mona in the back, and then Marian.
Yeah, I have a more practical question. So international arbitration is an international playground. You also mentioned an arbitration in Hong Kong. So I was wondering whether you travel a lot, or is it nowadays via Zoom?
Yes, the impact on Zoom on.
I used to travel a lot. And one of the cases we were talking about, one of the questions, favorite cases, was a case in London, and it went on for 6 years. There were 4 different phases, and there were 5 multi-week hearings. And it was against Emmanuel Gaillard, Sonatrach, Sherman Sterling. And I was in London just, constantly for long periods of time. I also had a case in Japan, 1990, 91. And I was there probably 6 months, 7 months out of 1 year. So I used to travel, and then we had the pandemic, and that just shut down travel completely. And now I'm sort of at a stage where I'm trying to push travel down. And we had a case for a big energy company in Thailand. And, the client comes to me and says, I want you to come to Bangkok. And I said, well, I really think this other person is better suited for this. And he said, no, we want you to come. And I said, okay, well, if you want me to come, I want this junior associate to come with me. And they said, fine. And so that was, one instance where I couldn't escape the travel. But yeah, there's a lot of travel.
I will jump in and say, though, I do think that it's expensive, all that travel, and it's the clients that pay for that. And I do think there's more pressure now that people have realized that some things can be handled by Zoom. I don't think that in-person and Zoom are the same. I don't think they're always equivalent. I think there's things that you really do get out of being in person. And I think you need to be judicious and think about whether the particular, hearing or whatever it is needs to be in person. And I think the world is moving in a direction where procedural hearings and things that used to be in person are transitioning to Zoom, because the arbitrators were traveling a lot too, right? I think for everyone.
There's also the impact on the environment,
Exactly.
right? And there's a big movement in international arbitration towards greener arbitration, reducing your carbon footprint through travel and printing documents in paper format and so on. Marian.
I was going to ask, in terms of situating ourselves in the best position to get into the field, what do you guys think about geography where we are? I sometimes feel like California is at a little bit of a disadvantage as opposed to DC or New York, and I was just wondering if there's truth to that.
I do believe there's more arbitration happening in DC and New York. international arbitration specifically. It's not to say that there aren't international law firms here. I can even say with Arnold and Porter, we do have a practice group here. We have one of our leading partners who's also practice group chair is here. But at the same time, the rest of the group, the majority of them are in DC, and then the other portion of them are in New York. So
I would make the point beyond California and DC, New York, but if you can be geographically flexible, as you pointed out, either because you have language skill that allows you to do it, or you're just willing, that opens up all sorts of possibilities, because in most big law firms, you cross staff matters. Most of that's why remote working didn't change my lifestyle too much, because my associates tended to be all over the world anyway. You just learn to work on different time zones, and, someone would send you something and their night, it would be your morning, you'd have the day, you get into that rhythm. And so if you can be willing to go wherever the opportunity is, you'll definitely open up a lot of possibilities for yourself.
Yeah. The other thing is, the way I look at this is Washington's really a hub for investor state. New York's definitely a hub for international commercial arbitration. It's the main hub in the US. And I think based on ICC statistics, and this may be from a number of years ago, the ICC had maybe 47 new cases that were venued in New York, and San Francisco was second that year with 17. And I think Houston had 11, Miami had 13. But it's true, there's more international arbitration on the East Coast. There's more firms that do it. And there's more practitioners that have dedicated practices in international arbitration. There's more competition too. And the firms that tend to do it in California now are the ones that have a very pronounced international strategy. So Music Peeler is, I think, an exception, but they are the big firms like Jones Day. We have, 41 offices throughout the world. We have international practitioners in Europe, the Middle East, Asia. San Francisco is a hub for our practice, DC, New York, Miami, Houston. And the same with, like a Sidley, Norton Rose, Fulbright, same thing, White and Case, Arnold and Porter is bicoastal, has that international strategy. There's some firms that had big international arbitration practices and then pivoted to a domestic focus, because the domestic practice tends to be more highly remunerative. And so rather than dilute partner profits with, all these foreign offices, what they do is they concentrate on, domestic litigation and, a large transactional practice. Go with a firm that has this pronounced international strategy with offices all over the world, and you go to one of their offices that does international arbitration, that's a possible in. And the fact that these firms have offices that do international arbitration on both coasts is beginning to blur this distinction between East Coast and West Coast. So you have practitioners in the Jones Day San Francisco office that are working on investor state cases with the Washington group. And then we also have, the Washington lawyers working with us on different cases. So there's a lot of cross-fertilization, as Jonathan pointed out.
That's
I
great
should definitely
advice.
add to that too, because we have like a huge office in London and international arbitration, and all of our teams work together.
So it's 6:30. I feel that we should bring the panel to a close. I know the conversation isn't completely finished yet. Do continue over the reception. We have some food and drink. Nancy, I wish you could be with us, but maybe next time. You've got really a brain trust and a wealth of experience here. Don't miss out on the opportunity. Talk to these folks, get more information, educate yourselves, and join this field. Thank you.
Thank you, everyone. Thank you, Hero.
No, it was funny. I saw, I noticed you.
Like over something like, oh, yeah.
Sorry, she couldn't be right. I've emailed with Quincy, but I just like this person. Well, you'll get through it. Don't worry. I love doing these panels because it's like so interesting.
Yeah, I
Everybody.
Some other. Yes. That is a good question. I mean, like, I can.
You know, like you.
Why don't you contact me? Do you know, are you at Hastings or, I mean, I.
Oh, sure.